Okay, good morning, everyone. Welcome to today's talk hosted by the Philippine Chinese Law Center. And today we are very honored to have our guest speaker, Professor Takamizawa Osamu. And Professor Takamizawa is Emeritus Professor of University of Tokyo and Adjunct Chair Professor of Shandong University. And he is a leading scholar on Chinese law in Japanese academia, and especially specialized in the dispute and dispute resolution in modern China, and the legal history of modern China, as well as legal sources for Chinese law. And he has written many books on the Chinese law, and including the dispute and dispute resolution in contemporary China, and the introduction to contemporary Chinese law, which is in its 9th edition from 1998 to 2022, and which is considered one of the most systematic and authoritative textbook for the Chinese law in Japanese academia. So today, Professor Takamizawa will share his thoughts on the historical review of the Chinese legal studies in Japan, of how Japanese scholars from 6th centuries and until present to study and evaluate and understand the Chinese law. So we will have Professor Takamizawa for his talk around 15 to 60 minutes, and we will open the floor for Q&A for the last half hour. Professor Takamizawa,
thank you. First of all, I appreciate the Philip K.H. Wang Center for Chinese Law, Hong Kong University, and Professor Lü-Ling to give me a chance to introduce the history of Japanese, studies on Chinese law in Japan. So, and also today, my voice is a little bit awful because this is a kind of seasonal event in autumn. So, sorry. I had several chances to do similar presentation. This is a part of the project of institution for advanced studies on Asia at the University of Tokyo to introduce Chinese studies in Japan. And finally, I wish to publish a book. This is a part of it. And the first step is for class at the University of Tokyo. And the second one is for a China Academy of Social Sciences, but only 15 minutes online. And the third is this year. I gave a kind of presentation for students from Chongqing University. And the fourth, not in the paper, but for Shandong University this September. And then today, I have a chance to introduce studies on Chinese law in Japan. And okay. And today, there are a lot of names of so-called legends. And if you feel interested in studies on Chinese law in Japan, or specialists, I would like you to use the names for search or prompts. The first session is why need to study foreign laws, and then 1, 2, 3, 4 phases. So first, what have been the reasons or purposes for Japanese people to study Chinese law or foreign law? The first reason or purpose is for legislation or interpretation of law. Traditional Chinese law had been a model for Japan between Asuka era, 6th century, to Meiji era, early stage, especially early stage of Meiji until 1885. The meaning of 1885, I retouch afterwards. And then in Meiji era or end of the Edo era, Western laws have been still are the model of Japanese law. And the second reason is for foreign affairs, especially business and family. And the third is studying a Chinese society through the law or legal phenomena. The first phase is in pre-modern. So in pre-modern days, so traditional Chinese law itself had been a kind of contemporary law and the model for legislation and interpretation after to Nara era, so 6th century to 8th century. The Imperial Court and its elites studied Sweet-Han Lü-Ling system for forming a Japanese Lü-Ling system. And then Heian era to Muromachi era. Muromachi era, so it already had been days or era of samurai. The Imperial Court had and shogunate studied Lü-Ling system for interpretation of Japanese Lü-Ling codes. And the specialists called as Nyoboka in Japanese. And this is the image of Shotoku Taishi or Princess Shotoku or Princess Umayado. Umayado means horse house. There was a kind of legend that he was born in a house horse, just like Jesus Christ. So, and this image is the old 10,000 Japanese yen bill. So Japanese, so how may I say, the typical image of the Shotoku Taishi is this image, and so and also here's a representative, one of the representative persons of 16th to 17th, 7th centuries elites. And then in Edo era, 16th century to 19th century, Confucian scholars, Jusha in Japanese or Ruza in Chinese, as advisors for shogun or daimyo domain laws. They studied Chinese law, especially a Ming legal system. And the early days in the Meiji era, so 1868 to 1885, government, Meiji new government still used the Japanese Lü-Ling system and the law books by Edo Confucian scholars. That those are still had been important texts until 1885. And in 1885, so Western, especially British cabinet system was established in Japan. So Japan is now far from the traditional Lü-Ling system. So that means Naikaku, Neiku, there's two kanji letters or Chinese letters. So not same as Chinese Neiku, but a kind of cabinet from European concepts. And the right image. The right image is Tokugawa Yoshimune, the 8th shogun, and he was very eager to study law and ordered Confucian scholars to study Ming legal system. And one of the representative Confucian scholars is, was Ogyu Sorai. The left image is the Ogyu Sorai's, so how may I say, another kind of image. And then the story became the modern era. So late 19th century to early 20th century. Another aspect of studies on Chinese law that for colonial government after Sino-Japan War, except for Okinawa and Hokkaido, colonial research was had been started, sorry, and the first is customary survey in Taiwan from 1895. And then after Russo-Japanese War, Japan got the kind of territory in South Manchuria from Russia. So they started customary survey in South Manchuria. In these surveys, there were two persons who were responsible for this kind of survey. The first is Goto Shinpei. He is the Secretary of Civil Affairs at the Taiwan Governorate, and then became President of South Manchuria Railway. And under Goto Shinpei, one scholar, how may I say, took a kind of leadership for civil law research. Okamatsu Santaro, he was a professor of Kyoto University or Kyoto Imperial University, and they did a kind of survey activities. And the left is Goto Shinpei, and the right is Okamatsu Santaro. Since 1920s, Japanese scholarly society has been influenced by the idea of living law or Lebensrecht by Eugen Ehrlich as an academic activity. So they, how may I say, not for colonial purpose, but a kind of for that kind of academic purpose. So Japanese scholars took a customary survey of northern Chinese rural areas in early 1940s. Please notice the year early 1940s. So still, however, we should keep in mind that although it is under the academic purpose, but is it pure academic or not? So that is a very difficult problem because the survey was taken under Japanese military occupation. So there have been a difficulty of evaluation of the results or fruits of the survey. So ethically, right or not, because under the occupation, and then survey targets were farmers or peasants on in rural area under the occupation. So, how may I say, the result or the data itself are correct or not. This is another problem. But we can see the vivid answers in the report. So, so it is very difficult to, how may I say, evaluate. Anyway, except for colonial purpose, so Japanese scholars did a kind of academic survey in China. And the second phase is that of studies on traditional Chinese law as a legal history. So not the contemporary law, but as legal history. So, and I try to divide two steps, before NAKADA and after or since NAKADA, because NAKADA Kaoru, he was a professor of the Imperial University of Tokyo. He went to Europe to study legal history, and he came back from Europe and restarted to work for the University of Tokyo. So before NAKADA, there were some specialists. studied Chinese and Japanese legal history, especially a Lü-Ling system for yusoku kojitsu. Yusoku kojitsu is a Japanese word. That is a kind of knowledge system which includes studies of government organization or ceremonies and customs based on the ancient precedents. This is also an important thing, especially when holding ceremonies. But then, NAKADA, after NAKADA, he studied legal history as comparative studies of government or governance system, or referring it to culture through historical materials and sources. And his jurisprudential basis were, one is natural law, and the other is historicism. And he had two excellent students. Ishii Ryosuke was a specialist of Japanese legal history, and Nida Noboru was a specialist of Chinese legal history. And then go to Nida, Professor Nida. Nida Noboru was one of the most famous scholars in studies of Chinese legal history, and also his academicism can be divided into two phases, before 1945 and after 1945. So I call, I will call him before 1948. 5 is Nida A, and after 1945, Nida B. And Nida A, his academic style is just proof studies. And the one of his major fruits is Tore Shui, restoration work for lost text of Ling Code in Tang, and also he did and published a book of Toso Horitsu Bonjo no Kenkyu, studies on legal documents of Tang Song. This is the Nida A. And also, we can see Nida after 1945 is just a Nida B. He changed his academic style from proof studies to theoretical studies, especially of materialism. Oh, sorry, I'm wrong. So, yes, materialism or Marxism view with a little bit mixed with Weber. This kind of style is a typical one since the elites in humanities or social sciences from 1930s to maybe 70s. So I may say materialism and Marxism and a little bit Weber. And the student of Nida A was Ikeda On. He had many books, and the typical representative one is Chugoku Kodai Sekichou Kenkyu, studies on Chinese historical archives of family register. And there was a student of Nida B. He is Fukushima Masao. He did study of Japanese legal history. So the second one, below one. So Chiso Kaisei no Kenkyu, studies on land tax reform. This is the Meiji era in Japan. And also he studies the legal system of People's Republic of China. He published a book, Jinmin Kosha no Kenkyu, studies on people's commune. I'm sorry, I had only Professor Ikeda on picture, and I have not gotten the image or picture of Professor Fukushima Masao, sorry. And Ishii Ryosuke had an excellent student, Shiga Shuzo. He became a special research student in 1943 at the Imperial University of Tokyo. Special research student was an only one good thing policy by Tojo Hideki's administration under the war. Special research students were exempted from military service. And he, the first, write a book of 中国家族法の原理 Principles of Chinese Family Law. And the book has a Chinese edition by Zhang Jianguo in Beijing University. And then he wrote many books, for example, 近代中国の法と裁判 Law and Suit in Qing China, and other works for it. 中国法制史資料法典と刑罰 Codes and Criminal Punishment in Chinese Legal History, and then 続近代中国の法と裁判 This is the last book of him, Law and Suit in Qing China too. He tried to extract the Chinese legal principles from a lot of text or context. And he described the Chinese legal principles by Western legal discourse and ordinary Japanese words through historical archives. This method made Chineseness stand out, I think. And he had some excellent students, Nakamura Shigeo and Morita Shigemitsu, Terada Hiroaki. They were the specialists of Qing legal system. And Harofo Senga, he's a specialist of Chinese law and Chinese social order. He wrote a book of introduction of Chinese law in German, and he also famous for his book of 36计 36 strategies through this kind of 36计 explain Chinese social culture. This is the, how may I say, legal studies of legal history. And then the third stage, the modern era, studies on the modern Chinese law in Japan. How may I say, so-called by me, modern Chinese law is from 1842 to 1949. And the first step is as contemporary law. So in late Qing era, Japanese, some scholars or specialists went to China under Qing dynasty as advisors or teachers. As advisors, they are in 修订法律馆 Office of Law Revision, and as a teacher, 京师法律学堂 Capital City School of Law. And four persons, Okada Asataro, Matsuoka Yoshimasa, Ogawa Shigeichiro, and Shida Kotaro. Sorry, so many Chinese and Japanese letters. Okada Asataro was a criminal law and criminal procedural law professor, and Matsuoka Yoshimasa was a judge and a specialist for civil law and civil procedural law. Ogawa Shigejiro was not a professor. He worked for Shihosho Justice Department, and he was a specialist of penology. 禁欲学 penology, is it right? Criminal law, right? Okay. Anyway, Shida Kotaro was a specialist of commercial law, and they joined the to make late drafts of laws. For example, 大清民律草案、大清三律、刑律、民事诉讼律、刑事诉讼律草案等等。And Ogawa Shigejiro designed the capital city model jail. That image is the 金石梦放监狱 that is a model jail at Peking. And after then, so in the 1930s and 40s, this is the second phase of modern era days. So, how may I say, they organized, so Japanese scholars and specialists organized a kind of society for study of legal system in the Republic of China. That in Japanese, 中華民国法制研究会 since 1930, and the end of the year, it's not sure, clear, maybe 1945 or 46. The participants are legends of law faculty or lawyers who they were interested in and respected newly built Chinese modern legal system. Murakami Sadayoshi was a lawyer, and Otani Masakatsu, I have no information for him, sorry. And Wada Kiyoshi was a famous historian, and Miyazawa Toshiyoshi, constitutional law, and Tanaka Jiro, administrative law, and Wagatsuma Sakae, Kawashima Takeyoshi were a civil law professor, and Hirose Takefumi, even he was a lawyer, but he was a specialist of civil law. And also, Tanaka Kotaro, Suzuki Takeo, and Ishii Teruhisa, they were the commercial law professor, and Kikui Tsunahiro, Kaneko Hajime were civil law professor, and Onoseichiro Dando Shigemitsu were criminal law and criminal procedural law professor. And Egawa Hidefumi was a professor of conflicts of laws. So they were the so famous big names of the law faculty at the University of Tokyo. And I use the word of respect because the Japanese modern legal system was established in the 19th century, especially civil code was or has been influenced by French civil code. But Chinese modern legal system was established in the 20th century, especially civil code was influenced by German and Swiss system. So Japanese civil law professors, how may I say, envied and respected the law legal system in PRC. So I use the word of respect. Sorry. One of the book of the fruits or publication of the society commentary on the property right of civil law, Republic of China, volume 1. They published a series of commentary on Republican Chinese law. And two, as for two, how may I say, not published. I was wondering, how about two? Why? So, and the answer was in the library of the Institute for Advanced Studies on Asia I worked for, and there was a box, and in the box there is a draft of volume 2. Now I'm arranging the drafts and to publish it. And another pattern is in modern era is collecting books and archives. The typical and representative example was Oki Kainichi. He was a lawyer and also collector of legal books and archives of Chinese law. He was a lawyer, but his working place is Tianjin and Beijing, so he bought a lot of books. And now it became an Oki collection, and it is at the Institute for Advanced Studies on Asia, and the Institute published a catalog. And Chinese famous collector Mr. Tian Tao, he republished the catalog in China. Perhaps you can see it. And another one is Nida collection. Nida Noboru also collected a book and archives in 30s and 40s. But half of his collection burned out in an airstrike under the war. Luckily, the half of it, remaining half of the part became the contents of Nida Bunko or Nida collection at the institute. And except for such kind of in the jurisprudence, some historians were interested in the legal history, modern legal history in China. Shimada Masao studied the process of modern law making in late Qin. And Shiga Shuzo's lecture at the University of Tokyo included modern Chinese legal history in Japan. So in general, so-called Chinese legal history, the story ends at the Qin dynasty. And if you study contemporary Chinese law, so it starts at 1949. So how about modern era? So this is a kind of, gray, not gray area. Anyway, very few people are interested in Chinese modern legal history, but Shiga's lecture at the University of Tokyo included modern Chinese legal history. So his lecture ended the story in 1949. And the fourth phase is the story of studies on contemporary Chinese law. That means the legal system of People's Republic of China, and also includes the basis of Chinese Communist Party, so-called the NGT based area. The first stage, so in 1949 and early 1950s, some Japanese started gathering information over diplomacy. especially by the first is Ministry of Foreign Affairs, and also Cabinet Intelligence and Research Office. And then academic activity started. NIDA and Fukushima were interested in not modern, contemporary Chinese law, and Miyasaka Hiroshi, he graduated Waseda University and became Senshu University professor. He helped NIDA and Fukushima to gather a research resources. And Fukushima Masao retired at the University of Tokyo in 67, sorry. And then he went to Waseda University after his retirement, and surrounding him, so there had been some excellent students at Waseda University. And at the time of first tide or China boom in Japan came. For example, restoration of lawful rights of the People's Republic of China at United Nations in 1971, or normalization of diplomatic relations between China and Japan in 1972. So this is the first tide or first boom, China boom in Japan. But Fukushima's student at Waseda, let me say, they were too much smart, or how may I say, knowing studying Chinese law, contemporary Chinese law was very extremely important. They knew, but they are too early to start the academic life. So it was very difficult to hold an appointment or academic positions. So some of them are, how may I say, had a difficulty to get job. And also, surrounding Waseda and the University of Tokyo, there were two legends. The first is Konoma Masamichi, undergraduate and master course at Waseda, and afterwards he came to University of Tokyo, and his degree was from Hokkaido University. And Tanaka Nobuyuki also graduate at undergraduate at Waseda University and graduate school at the Tokyo Metropolitan University. So they themselves, including them, they themselves, perhaps including Fukushima and NIDA B, were socialists, and they were interested in Chinese, contemporary Chinese law as a new type of socialist or socialist law. And except for academia, there had been some exchange trial, or I may say events of practitioner lawyers of law, 1950s to 1965. They did exchanging activity with People's Republic of China under the situation with the diplomatic relations between China and Japan. And then 1966 to 1980, so no way, no change, no exchange activities. So after, since 1981, so new steps began for exchange. This is the example of the results. For example, 1953, 1960, 61, 65, 65. So just before the how may I say, Cultural Revolution. Before the revolution, they did, and then 1981 restarted the exchange. And one of the characters of Chinese, how may I say, studying Chinese law for contemporary Chinese law is a point from the studies point from the point of view of constitutional studies, and also that I call the socialist law. ハリウ世吉 1927 to 2020. He had been Tokyo Metropolitan University professor. He had been a student of Kiyomiya Shiro. Kiyomiya was also a famous constitutional specialist, and he started the career at Tohoku University, then had been a researcher at the University of Tokyo, and then Metropolitan University, and also Asai Atsushi. He had been a student of Suzuki Yasuzo. Suzuki Yasuzo was a specialist of constitutional law, especially French revolutionary thoughts and socialism at Aichi University. Asai had been an assistant professor. Anyway, okay. これはいいです。So, sorry, there are a lot of names, so it's a little bit confused. And the conclusion is that we saw several approaches by Japanese to Chinese law. One is as contemporary law. The first is practice, so lawmaking or interpretation by lawyers, officials, or advisors, and also academicism, and also as history. And now, contemporary studies with Western law, Japanese law, yes, they are still, they are, let's say, they had a little bit results or fruits in the comparative studies with Western law or Japanese law. But next step should be a comparative East Asian laws. And I expect younger generation to do it. Thank you.
Thank you for providing us this very wonderful and very insightful historical review of the different scholars, and especially provide so many actors in the whole histories. As you see, but what shocked me most is that because you get educated in law in Chinese mainland Chinese, or you have read any Chinese legal histories, one of the narratives you must learn is that modern Chinese law is learned first from Japan, and then from Europe, and then the China learned all European laws from Japan. But what today Professor Kanizawa provide us is actually those Japanese legal scholars actually respect the Chinese, the law of the ROC from the 1911 to the 1930s. And so that's not how the Chinese legal scholars apply or respect the Japanese law, how Japanese legal scholars apply or respect Chinese law. So that's what changed my views on this point. And also, there are so many actors of the historiography here, and we see that they're involved in the positions of the academia and profession, also the politics. And under the war times 1930s, 1940s, we see they do the service in North China and in Manchuria, and this involves both politics, colonial, but also they have some academic commitment to do this. And also after the establishment of the PRC in 1950s, what I haven't noticed history before, that there are exchange of the legal practitioners,
Yes.
even without any diplomatic relations. So we see that these lawyers are actually very important to bridges to countries, even in difficult and competing times, and which really research, or which really it maybe we do more, as you said, do more study no matter it's from the comparative East Asian or comparative East Asian legal histories to see how it's going. Okay, so I will open the floor for some Q&A you might have, and please have questions.
Much for your presentation. I have a question about pre-modern era and Yayoi Jidai to Heian Jidai. The influence from China really went through Korea mostly, and I'm wondering if that sort of Korean influence has continued beyond these pre-modern periods. Your story is very bilateral, China, Japan. Does Korea feature in that relationship at all, or is that just a pre-modern relationship?
So, as for the history of thoughts, especially Confucian or 朱子学, yes. So, Japanese scholars studied Korean methods or thoughts because in Edo era, so there are more than 10 times of the a delegation from Korea to Japan, and Japanese Confucian wanted to meet them to study how to interpret the Confucianist text. So this in this phase, so Korean influence is very big, but in law, so as directly from China, or how can I say, so Korea, Qing dynasty, and Japan, they accepted the Ming codes. So how can I say, so it is a little bit peculiar, or how can I say, odd that Qing, Korea, so Choson and Japan, they do not have some relation in your legal system, so no relations. Just they respect the Ming system. So in the how can I say, as for legal system, it is very difficult to see Korean influence, but thoughts, yes. So there are many exchanges. Thank you.
Well, I should ask about, because I'm very curious about the revolution after 1945. So it's very obviously because of the civil war of China that the Communist Party won the civil war of the 1945. So the NAKADA began to start the socialist and the Marxism. Is that the reason?
So maybe in the base of the humanities thoughts or method of social sciences in the 1920s, 30s to the 1970s, the base were or had been, how may I say, anyway, a kind of materialism or Marxism. So Nida itself, himself, I think he knew the such kind of things, but his academic style had been a kind of proof studies before the 1945, and then 1940. After 1945, so how may I say, he perhaps he was released from the such kind of proof studies, because this proof studies was influenced by NAKADA Kaoru. So, and the first he thought that he should what kind of words obey or follow the Professor Nakada's thought, and then after 1945, so he did such kind of materialist studies, but I think he did not succeed, or if you read his book, so very interesting, and in the books before 1945 and his books after 1945 a bit not so interesting, or it is very difficult to say. So not succeed in such kind of things.
So there, it is not because of the Kuomintang, the Civil War and
how may I say? Yes, it is not the. I think he was not influenced by the result of the Civil War. Yeah.
you already have this.
Yeah.
Thank you, Professor Ekamisawa. Very interesting talk. I think we have seldom organized such a talk on Japanese studies of Chinese law and Chinese history. So I think your talk is very useful. You mentioned some studies of customs in Taiwan, maybe early 20th century. But you also mentioned that there were few scholars studying the modern era between 1911 and 1949. So what about after 1949, Taiwan after 1949? Is there some Japanese legal studies of Taiwan after 1949? And so maybe comparing it with developments in mainland China.
You mean Japanese scholars, the situation of Japanese scholars to study Taiwan legal system?
Right? Taiwan after 1949. It was before 1949.
Yeah. So,
Republic of Chinese.
Yeah. After 1949, there were few people, or most no one studied Taiwan legal system in mostly before 19. Yes, before 2020. So yes, before 1990. So the Professor Wan Tai-song of Taiwan University, he published a book books of Taiwan legal history, and then Japanese scholars started to be interested in Taiwan legal system. And also, for example, learning Chinese language. So just before 1990s. So if you are you want to study Chinese language, so should go to mainland. If not, so it's a kind of betrayal, or how to say, it's a kind of socialistic influence in Japan. So, and then perhaps democratization in 1980s to 90s in Taiwan. So people are interested in Taiwan legal system, including Taiwan and including Taiwan legal system.
There is an empty space.
Yes, empty, yes. 1949 to 1970, yes. It's a kind of empty of studies.
Do you say studying Chinese language in mainland or Taiwan, which is
which is the mainstream should be in mainland. And then, so after 1990s, so if you're interested in studying Chinese language, so you can go to mainland, Taiwan, Hong Kong, or sometimes Singapore. Okay, always okay. This is the new tendency of this century.
Maybe I'll start. Yeah, thank you so much, Professor Kaoru, for the presentation. You mentioned that the scholars that study imperial law in China include law. And I just wonder if you could maybe say a little bit about the current scholarship on that. Has there been any major shift in the approach to the study of imperial law in China, and whether there are different areas of interest?
You mean in college or
In academia.
academic? Yeah. So imperial legal system, Chinese imperial legal system. So studies on the imperial legal system. I think studies at started at the 19th century and 18th century. That as I said, that just a kind of knowledge system on ancient things, and then as a modern historical studies or modern legal studies. So studying imperial legal system became the subject or in university as just the story of the 20th century. Yes. Hi.
Is about the current scholarship.
Current scholarship. You mean college scholarship?
Japanese scholars are contemporary on Qing systems. That's key to the answer.
Yes. So today the names so names of the legends. One so condition that born before 1955 because they are legends. So and if so, the story does not include the younger generation or myself. So now in the younger generation, so the first legal history itself is not how may I say 必修科目 yes, no. So so there are few universities of having the class of legal history, very few. So the first problem is that it is very difficult to find job. And then, so legal history is not one of the subjects of bar exam. So also, it is very difficult to find job. So, but some of young students or scholars get job or in the law faculty and also as a historian. So interested in Chinese legal history, including modern legal history. So there are maybe 3 or 4, very few, but still they are. So study Chinese imperial legal system.
Any questions?
Thank you, Professor. I have one question because you just said that there's few scholars who study the legal history from the early modern Republican China. So is there anything to do with the Sino-Japanese relationship of that period?
You mean the relationship between China and Japan in those days?
Yeah.
Yeah. So and the Japanese diplomatic strategy. So after Sino-Japan War to 1920s, Japanese diplomatic strategy was a kind of how can I say in English? 中国保全論, how do you say in English? So protect China's independence. This is a Japanese diplomacy. And then, so Japanese universities or schools accepted many huge number of Chinese students, including law. So, and some Japanese, not so many, some Japanese lawyers went to China to work for some companies, and they also exchange or research. So, 満鉄調査部, how do you say, research section of South Manchuria Railroad. They have 100 and 200 researchers. So it was a how do I say, major power to study Chinese society, including legal situation. But relationship, so how do I say, in legal history, so there were some relationship between China and Japan. Some of them did it as how do I say, major works, I think. Relationship. So I can say many Chinese students were studying at the law faculty at universities. So in this meaning, there had been a kind of relationship, huge amount of yes.
Okay, so any other questions? Okay, so let's welcome again for the